So welcome everyone, thank you for joining us. I'm reliably informed that we have automatically muted you and switched off your camera, so it may well be you don't need to worry about that at your end. Please try and avoid fiddling around with any of the PowerPoint slides and just sit back and listen. And you can pose any questions via the chat function, which we will probably pick up on mainly at the end. But if you pose them and we spot them as we work our way through, then we'll see if we can do them as we go through. Obviously, the standard disclaimer applies in relation to any advice we give or thoughts we share on this particular topic during the course of the proceedings, or indeed in response to any particular questions you might raise in the chat function. So the topic we've got today is professional advisors' scope of duty, and I'm pleased that I'm joined by John Virgo as a co-speaker, and also that we have the pleasure of welcoming His Honour Judge Russen QC is joining us today to say a few introductory remarks before we get into the meat of the talk. So can I pass over to you, Judge, and thank you very much for joining us.
Thank you, Hugh. And as always, good morning, everyone out there. Happily for you, your cameras are off. I can't therefore see whether you're already suited and booted or still pajamaed. But welcome anyway, and I'm honoured and flattered, as always, to be invited by Guildhall to say a few introductory words. This, I understand, is their second commercial law-related webinar or online talk. There have been, as I understand from you, other talks in other specialisms. And of course, it's normally at this time of year, possibly a bit earlier, that I would be kindly invited by Chambers to chair their commercial law seminar, usually at some place near the harbour side, with a handsome breakfast and 80 or 100 delegates attending. And indeed, at some point in early 2020, one might have thought that Hugh might be ringing me up to pencil in a date for that. With a view to you all attending, possibly some of you bearing the legacy of a foreign holiday tan. But we all know what happened to that. No commercial law seminar was held. I'm not even sure, Hugh, that you had your online talks up and running at that stage. And we were not waving goodbye to COVID-19 in our rearview mirror. Happily, we do seem to be doing so now more and more. As you know, many hearings are reverting to attended hearings, though many will remain remote, probably forever and a day. Some typical examples will be uncontroversial PTRs, direction hearing, many CCMCs, not all of them, particularly the weightier ones might benefit from attended hearings. Adjudication enforcement in the TCC context, that's, I think, been written into a practice note or something equivalent to that, to the effect that those will be remotely held in the future. So the pesky pandemic, for good or ill, has had some earlier than expected longer term effects so far as the mode of the court's operation is concerned. I want to, just as an aside on that front, apologise to those commercial court user group members for the fact that I think it's been well over a year. I think I was struck down with an eyesight issue in November 2020, when we were just about to have a meeting, and we haven't had one since. And I'm very conscious that one is overdue. Those members may have received yesterday an email from me, which is about the draft, revised draft Circuit Commercial Court Guide, interlinked as it is with the Commercial Court Guide. And I had been putting off a user group meeting in the hope that perhaps fairly late on in this year, we might have a meeting about that. But only this week it was decided that the better way forward was for the respective regional CCC judges to circulate the guide and to invite comments, I'm afraid in fairly short order, from users as to any improvements that might be made upon the drafting. And as I said in the email to those that the guide has been confidentially circulated, if you are able to come back to me by, well, really in the next week or so, the timing is quite strict because London are looking at this on, I think, the 9th of December. But anyway, that is an aside, and I make the small p promise that we will have a user group meeting, whether attended, remote or a hybrid, at some point early-ish in the new year. And as we begin to return to something like normality, I'm sure that next autumn, Guildhall will be holding their full-blown commercial court seminar in the way that I earlier described. But that brings me to today's talk, the theme of the talk being professional advisors' scope of duty. You are going to, I'm sure, benefit from a rewarding talk given by two leading members of Guildhall Chambers. Hugh Sims QC and John Virgo will already be very well known to you, and they're already well known to me in my relatively short time in Bristol, although it's now, I think, 4 years. Hugh is also, as you probably know, a Deputy High Court judge with his circuit commercial ticket. So issues of conflict aside, he is, as I understand it, available for business here and elsewhere, sitting in that capacity. Hugh has recently got the Court of Appeal to show me the error of my ways in one particular case, on one facet of it at any rate, involving allegations of directors' breach of duty. And I can only say how silly I was to follow the reasoning of two eminent chancery judges on the strictness of the approach to disclosure of potentially conflicting interests, rather than to anticipate the leniency of a former commercial court judge. I have given Hugh permission to try to do the same in relation to one of my judgments, I think next year, early next year, in the Court of Appeal, in that he hopes to reverse a reverse summary judgment that I awarded against his client in a rather sad case, and I'm afraid another plague of recent times, involving authorized push payment fraud. In the nicest possible way, Hugh, I wish you a modicum of success on that hearing, but perhaps not victory. John Virgo has appeared before me on a significant number of financial mis-selling cases. He's the author of a book on market abuse, and I'm talking here about stock exchanges, not foul-mouthed fishmongers. But his experience does not stop there. John, I think, last appeared before me remotely in a TCC case last month. Now, today, they're both going to be speaking, as I say, upon the topic of professional advisors' scope of duty. This is a highly topical topic in that last week, in fact, I was on a Judicial College training course in which, if you chose the professional negligence module amongst a number of other modules to be chosen, a large part of the talk was on the case of Manchester Building Society and Grant Thornton, the decision of the Supreme Court, which I think will form the core element of Hugh and John's talk today. For my part, and I'm sure they will elucidate further, I think the Supreme Court, with its 6 propositions dealing with causation and remoteness of loss, have considerably assisted practitioners and judges with their checklist of matters to be gone through. The decision has done much to dispel the confusion that was generated by analogies with dodgy mountaineers' knees and the so-called Samco cap. And as I'm sure you'll hear, the counterfactual scenario now comes in as a sort of sanity check rather than the driving force in establishing causation of loss. But with my camera turned off and my microphone muted, I will now pass on to your two speakers and hope to learn myself something further. Thank you, Hugh and John.
Thank you very much, Judge. And as ever, thank you for updating us on what's going on in the Bristol Circuit Commercial Court. And I'm sure all practitioners look forward to seeing you again in court and being in front of you in due course. So if we move on to the substance of the talk then, and in outline, what we intend to do is conduct an analysis of the principles behind a professional advisor's scope of duty as they emerge from the decision of the Supreme Court in Manchester Building Society and Grant Thornton, and also the sister decision, if I can put it that way, of Meadows and Kahn, both judgments being handed down at the same time, comprised of the same members of the Supreme Court and intended to be read together. And with those points in mind, then go on and look at some of the past decisions and the impact of MBS on our analysis of the scope of duty of accountants, auditors, financial advisors, valuers, solicitors, and other professionals. So with that overview in mind, over to John.
Thank you very much, Hugh. I hope now I've successfully taken control of the slides for the moment. We thought we ought to begin really with just a brief outline of the facts in the Manchester Building Society case, because they are not without their both factual and legal complexities. And the background to it came about in this way. Between 2004 and 2008, the Society acquired a book of lifetime mortgages, or built up a book of lifetime mortgages valued at some £68 million. A couple of years, in the couple of years that followed, between 08 and 10, it went on to acquire £40 million worth of Spanish lifetime mortgages. I'm sure most, if not all, people will be well familiar with the way in which lifetime mortgages work. They're normally available to people over 55, 60 years of age who have equity in their homes that they can release, and they do so in exchange for an interest charge which is simply rolled up against the property and not realised until the property is sold, either on death or earlier disposal. The UK portfolio was hedged by 14 swaps with a notional value of £74.2 million for a fixed term of 50 years. You'll note that the notional value of the swaps was somewhat higher than the 68 million value of the portfolio, which I infer probably left the Society with some £6 million worth of headroom for any further lending in that way that it wanted to entertain. The Spanish portfolio was hedged again by some 14 swaps with a value of €57 million for terms of between 5 and 30 years. And the business model that the Society had adopted entailed the fixed rates in the swaps being below the lifetime mortgage rates. And so the Society was expecting to benefit from higher rates of interest through the lifetime mortgage portfolios than the outgoing liabilities it had under the swaps. The Society, of course, was and is an authorised entity with their operating pursuant to a Part 4 permission granted by the Financial Conduct Authority, in the context of which it has been obliged to maintain protective levels of regulatory capital, which required it also then to take into account the mark-to-market value of the swaps. Again, most, if not all, people will be well familiar with the proposition that a swap which is terminated before its end date can attract very significant break costs payable by the swap counterparty, particularly in circumstances where prevailing interest rates have fallen relative to the swap rate and are predicted to remain low for the foreseeable future. The way in which the mark-to-market value of the swaps fell to be treated was changed in and from 2005 as a result of a need for the Society then to record the mark-to-market value in its annual accounts, pursuant to standards set by the International Financial Reporting Standards. Now, in that context, Grant Thornton advised that the society could offset the carrying value of the lifetime mortgages against the mark-to-market value of the swaps. And the way in which that worked was that the future income stream from all of the lifetime mortgages could be calculated and netted back to a present day value, which gave a capital figure which could then be, as they hoped, close matched to the value of the mark-to-market on the trade. The accountants, Grant Thornton auditors, also told the society that they could assume that mortgages which were going to fall in earlier than the life of the swaps, so within 50 years, would simply be assumed to be replaced by replacement mortgages also ending at the 50-year end date and written at the same interest rates as the lifetime mortgage which had been terminated. And in that way, Grant Thornton assured effectively the society that it will be able to meet its ongoing regulatory capital requirement, and on that basis adopt the business model that it pursued. So what went wrong? Well, fundamentally, Grant Thornton's advice was wrong. First of all, there was no correlation between the 50-year swaps and the length of the lifetime mortgages. And for the whole proposition to work from a regulatory and accounting point of view, the two figures, the net present value of the mortgages and the mark-to-market value of the swap, had to be able to be close matched. Of course, if one sits back and thinks about it for a moment, it's most unlikely that an individual borrower at age, say, 50 will be sitting in their same property up to age 110 for the full 50-year term. And that what was a possibility which the court ultimately described as being vanishingly small, as is obviously the case. In that context, Grant Thornton's advice was also wrong to advise that the society could simply assume a substitution of an equivalent replacement mortgage. That was a practice which was simply not allowed by the so-called hedge accounting rules, which applied to the way in which the society had to account for the mark-to-market in its accounts. Grant Thornton in 2011 fessed up to the incorrect advice which it had given, which led to a need to restate its year-end accounts. And as you'll see from the slides, the results of the restatement were fairly dramatic. A reported profit of over 6 million suddenly became a loss of nearly £11.5 million. The net asset values were reduced from 38.4 down to just under £10 million. But the real problem was that the regulatory capital, which had been stated in the accounts at £20.4 million, moved to a deficit of just under £20 million. Now, as most people will know, I'm sure, the consequence of a regulated entity breaching its capital adequacy requirements is that it would have to cease trading, and the regulator would intervene and take away the Part 4 permission, and so the business would have to cease. And so some urgent remedial action was necessary. That took the form of the society terminating these swaps at a break cost of just under £33 million and selling off its UK lifetime mortgage portfolio for £68.4 million. That led to claims about which Hugh will now address us.
Thank you very much, John. So yes, focusing on the final bullet point on that slide, then what we're now going to home in on is the question of recovery for the break cost sum. In fact, the actual sum in consideration by the Supreme Court was a few million less than that, because there was a minor profit made on the sale, such that the figure was in the region of 28 million, but it doesn't really matter for present purposes. In relation to that particular claim, we're now going to track through the twists and turns up to the Supreme Court as relation to that particular claim and the reasoning in relation to it. I should say there was also a finding made by the judge at first instance of contributory negligence in the sum of 50% from memory, but we don't need to worry ourselves too much about that for the purposes of this particular talk. So focusing then on the break costs and what happened in relation to that element of the claim at first instance, the first instance judge concluded that Grant Thornton had not assumed responsibility for the break costs and shouldn't be liable. And secondly, that the break costs were market driven, i.e. caused by market volatility, not Grant Thornton's advice, and so therefore did not fall as a recoverable item. The appeal up to the Court of Appeal failed, but for slightly different reasoning, although the court rejected the assumption of responsibility approach taken by the judge at first instance. The Court of Appeal held that Grant Thornton had given information and not advice. Pausing there, of course, that echoes the approach which goes all the way back to the decision of the House of Lords in Samco and some of the observations made by Lord Hoffman there, which were interpreted as requiring everyone to consider whether or not this was information or advice. Of course, if it's under that categorization viewed as advice, then the advisor, subject to other potential foreseeability issues, is responsible for all the consequences of entering into the transaction. Whereas if it's information, the potential liability for that is viewed as being limited to simply the consequences of the information being inaccurate, or assessing that by reference to the information being, if it's otherwise been accurate. So they were really going back to that particular approach, which we've lived with and struggled with as practitioners for some years. Struggled with, I say, because of course it's not always easy to work out in the context of a professional advisor why something might be categorized as simply an information case rather than an advice case. And that particular issue, of course, was considered in more detail by Lord Sumption in the Supreme Court in Hughes, Holland, which we'll come and look at again in a few moments' time. But that formed the central reasoning of the Court of Appeal. And they went on to find that Grant Thornton can only be liable for the consequences of the information being incorrect. And MBS could not show that if the information had been correct and had been held, and if it held the swaps to term, that it would have been better off than it was by breaking the swaps early. So therefore, their claim failed. We then have the decision in the Supreme Court, and the Supreme Court ultimately concluded, in agreement with the Court of Appeal, that the first instance judge was wrong to adopt an assumption of responsibility approach, but also that the Court of Appeal was wrong to determine liability according to whether or not this could be said to be advice or information case. And so the Supreme Court was really teed up to look at the whole area again and give us advice and guidance as regards what the correct approach was. The Supreme Court said that to summarize the majority view, the correct approach is to ask what was the purpose for which the advice was given, i.e. what risk was the duty supposed to guard against, and does the loss suffered represent the fruition of that risk? I might add that that question, as rephrased, probably works perfectly adequately in most cases, but it may not be so straightforward in all cases, because it doesn't necessarily follow that advice is always given about risks, but we can obviously explore that on a case-by-case topic basis. The real touchstone that you should be focusing back on following the decision of the Supreme Court is what was the purpose for which the advice was given. The question, would the same loss have come about if the advice was correct, should not be used as a starting point to determine the outcome to liability, but that said, may be used as a cross-check in order to test whether or not the loss might be said to fall within the scope of duty in respect of for which the purpose for the advice was given. Just to drill down into the context of this particular case to understand how that was applied in this case, the majority view was that the purpose of the advice was clear. Grant Thornton advised MBS could employ hedge accounting in order to keep its regulatory capital at a level it could afford in relation to swaps to be held to term on the basis that they were to be matched against mortgages, that advice was negligent. It had the effect that they adopted or continued the business model, entered into further swap transactions, and were exposed to the risk of loss from having to break the swaps. When it was realised that the hedge accounting could be used, they were exposed to the regulatory capital demands which the use of hedge accounting was supposed to avoid. That was a risk which the advice was supposed to allow them to assess, and which their negligence caused MBS to fail to understand. Therefore, the break costs were recoverable because they were a loss connected with the purpose for which the advice was given and caused by the breach of duty. So John is now going to look at the sister or brother judgment of Meadows and Kahn.
Thank you. I think we can take this much more shortly, and the facts were much simpler than those in the Manchester Building Society case, but the principle of law behind both decisions is the same. In brief, the claimant in Meadows and Kahn consulted Dr. Kahn for advice about whether she was a carrier of the haemophilia gene. It's common ground that Dr. Kahn gave a negligent response to that inquiry and told her that she was not. The result was the claimant went on to conceive a child, and at first instance, Mrs. Justice Yip found that had the claimant been correctly advised at the outset, she would have had the fetus tested for haemophilia. That would have revealed that it was unfortunately afflicted with that condition, and that would have led to an early termination. In the result, the claimant gave birth to a child which was haemophiliac, but also suffered from an unrelated serious autism condition. The claimant brought a claim for damages, seeking and successfully seeking at first instance from Mrs. Justice Yip an award of £9 million, which was intended to cover the future cost of care so far as dealing with both the haemophilia and the autism conditions were concerned. That award was reversed by the Court of Appeal, which substituted a figure of £1.4 million, being the cost relating solely to the haemophilia condition. And applying the purpose test, the court asked what is the risk which the service which the defendant undertook was intended to address, and concluded that where a medical practitioner has not undertaken responsibility for the progression of the pregnancy and has undertaken only to provide information or advice in relation to a particular risk in the pregnancy, then the risk of foreseeable unrelated disability, which could occur in any pregnancy, will not, as a general rule, be within the scope of the clinician's duty of care. In other words, Dr. Kahn had been asked to advise about one particular risk, i.e. the risk of haemophilia alone. He'd not been asked to advise and test if it was possible to do so for autism, or asked to assume the responsibility for investigating all manner of possible conditions which might beset and befall a child. So that is an example of the new conceptual framework, which Hugh is going to unpack further now.
Thank you, John. Before I do so, I was going to just ask you the question, the audience might be interested. On MBS, do you think ultimately we got to the right place at the Supreme Court?
I think in both MBS and in Meadows and Kahn, on the particular facts of those cases, they make sense and they fit in with the rationale in the judgment. Yes.
So I think I'm persuaded on MBS that probably once you focus very keenly on what the purpose for which the advice was given, you can see that it was very much focused on the business model and protection of risk in relation to market volatility. So the mere fact that a loss was associated by reason of market volatility in the financial crisis shouldn't preclude the claim, because that was the precise purpose for which the advice was was sought or was closely related to it, if you can put it another way. What I wonder about in relation to the second case on Meadows and Khan is whether or not it is quite right, and in relation to the two figures, as I understand it, remind me, but there was a figure for just haemophilia alone and a figure for haemophilia and autism combined. And obviously it was the latter which the first instance judge awarded, but ultimately it was only the former which was successful. And I do wonder whether or not there might have been a third figure out there that might have been considered, which was the first instance judgment figure, but stripping out the independent separate costs associated which would arise in any event if a child who had autism had to be cared for. Because it would appear to me that the cost associated with dealing with a child who has haemophilia and autism would be much greater. That's my understanding of the facts. So I wonder whether or not actually there might have been another way of looking at it. Ultimately, of course, the first instance judge thought that all of it should be recoverable on the basis that she thought it wasn't fair to distinguish between a mother who wanted to terminate the pregnancy and a mother who had wanted to terminate any pregnancy. But ultimately, she took the view that all of it should be recoverable. But I just wonder whether or not actually there might have been another answer in that case. But anyway, it doesn't seem to me that intermediate point was explored.
No, well, I think actually, as we look at some of the other cases in due course this morning, there are nuances to quantum which simply get overlooked, I think, in the course of preparation, which is no criticism of anyone, that these are very complex issues, and it's difficult to foresee every twist and turn. And when you end up at trial, there's the regrettable possibility that one avenue might not have been fully explored.
Rather unhelpfully for solicitors who are looking for clear advice from counsel, or indeed clear guidance from the courts. They may have got some clear conceptual framework guidance, which we'll move on to look at now, but they may well get divergent views, both from the counsel who are assisting them, but also from the judges ultimately making the decision. Anyway, I think that the moral of the story is probably there's still quite a lot to fight for on the facts of any particular case, even though we perhaps have a clearer test to apply in terms of its articulation by the Supreme Court. So turning back to that now, then, the new conceptual framework, as I said, I was referring to the majority view throughout the first few slides. The majority view was articulated by Lord Hodge and Lord Sales, and their judgments were concurred with by Reed, Kitchen and Black, and they summarised what they described as the conceptual framework in paragraph 4 as looking at 4 different things. Firstly, the scope of duty question should be located within a general conceptual framework in the law of the tort of negligence. Just pausing there, that's obviously of some significance in the context of professional advice cases where there is ordinarily both a contractual obligation as well as a tortious one, but generally speaking, normally the issue that you're considering is a breach of reasonable skill and care concept. And so what we're dealing with here is treating that concept within the law of the tort of negligence rather than contract. But that's not to say that there may be cases arise where the particular breach that is under consideration does require you to look at contractual principles, or indeed to look at statutory principles in relation to regulatory breaches, for example, which John, I think, is going to look at in a short while. So it's important to keep in mind that whilst these are broad general points of principle, they don't apply in all professional advisor liability cases. The second is that the scope of the professional's duty is governed by the purpose of the duty, judged on an objective basis by reference to the purpose for which the advice is given. Thirdly, the distinction between advice and information cases should not be treated as a straitjacket. That was really the headline following the initial decision in relation to the Court of Appeal decision. And fourthly, the counterfactual analysis should be used as a cross-check to ascertaining the scope of duty, but should not be used to predominate. It should be subordinate to that analysis. Taking the conceptual framework a step further, then, the majority view was that we have, in effect, these questions, these 6 questions, to help us, guide us through our analysis of the cases, and in particular the facts. The first is the harm, which is the subject matter of the claim, actionable in negligence? I should stress that ordinarily that doesn't crop up in the case law that we look at, because actionability is normally a given, but there may be certain categories of cases where there's a claim, for example, for annoyance, which would be considered not, for example, to be actionable. Secondly, what are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? That's the scope of duty question. As the Supreme Court mentioned, logically, the majority view was that question kicks in right at the start, but often for the cases where one is looking at what loss is recoverable, it makes sense to actually get under the skin of that particular issue at a later stage, at stage number 5. But turning back then to the next stage after stage 2, stage 3, did the defendant breach his or her duty by his or her act or omission? Well, nothing changes there. 4th, is the loss for which the claimant seeks damages the consequence of the defendant's act or omission? So that's really focusing on the but-for factual causation question test. Again, nothing really different there. 5, is there a sufficient nexus between a particular element of the harm for which the claimant seeks damages and the subject matter of the defendant's duty of care as analysed at stage 2 above? The duty nexus question, this is perhaps where there was the most debate in the Supreme Court as regards this particular aspect of the reasoning. And as we'll come on to look at in a moment, Lord Leggett preferred more of a causation flavour to the analysis. Lord Burroughs preferred more of a policy-driven analysis. But ultimately, the majority view was that this is the question to be asked. One might think that there is some element of causative language there, because they're focusing in on the question of whether or not there's a sufficient nexus between a particular element of the harm for which the claimant seeks damages and the subject matter of the defendant's duty. But according to the majority view, it's not really a causation question. The question is really linking back to the question of focusing on the purpose for which the advice was given. In any event, that's the 5th question. The 6th is a particular element of the harm for which the claimant seeks damages irrecoverable because it is too remote, or other points to do with intervening causes, etc. So it might be thought that 6th element actually contains a sort of a catch-all of various other items, and there's always a risk, I think, of thinking that necessarily these contractual frameworks apply always the same in every single case. But certainly for the point of view of stress testing your case and thinking about its likely prospects, this is a useful conceptual framework to apply and consider when deciding whether or not the claim is one which is worth pursuing and has merit. Just briefly before we go on, just have a quick look at the minority views. Ultimately, the minority views didn't differ on the outcome, but contained substantial reasoning which supplemented or in some ways was in tension with the reasoning of the majority view. And the reason why I think it's quite helpful to look at the minority views is for 2 reasons. Firstly, when you read the judgment of the majority, it has copious references to and assumes that the reader has read the minority views. You can't really understand the majority judgment very well without looking at the minority views. It may be thought a slightly odd drafting style to have an initial judgment which one can't properly understand until one has read the minority judgment, which is longer, but there we are. That's the nature of the beast we're dealing with here. So far as Lord Legate's view was concerned, this is really summarised at paragraph 124, and I think it was by reference to counsel submissions in a case in another jurisdiction, where he concluded that they'd accurately summarised what the real test was in relation to what had been referred to as the Samco principle, which is that the principle denies liability where an alternate cause that is unrelated to the subject matter of the defendant's negligence is the true source of the injury. And I do wonder whether or not actually what Lord Legate has done there is to unpack actually what the majority are saying means by reference to sufficient nexus. It may well be he's put it in language which is in causation language, which the majority didn't ascribe to. But it does seem to me that that minority view might give us some more flesh on the bones as to whether or not a court is likely to conclude that the fifth factor in the majority view, i.e. the sufficient nexus factor, is satisfied. The second minority view, which the majority thought was closer to their analysis, that's debatable, I think, but was the speech and judgment of Lord Burrows, and in particular at 179, he thought that actually Samco was just best understood as focusing on the scope of duty in the context of the provision of professional services. Well, so far so good. And then at 212, he thought it was policy driven and really was just the question of what is a fair and reasonable allocation of risk. He didn't like the duty nexus phrase. And so far as duty was concerned, he thought that the Samco test kicked in when asking whether factually caused losses within the scope of duty. I have to say I'm not sure necessarily whether or not calling it a fair and reasonable allocation of risk takes us any further, or whether one is back to phrases which don't in fact elucidate where one's going to end up in any particular case. It seems to me that whilst duty nexus phrase is a novel phrase which is not so easily understood absent drawing by analogy with causation tests, probably that is a reasonably good touchstone as to where you're likely to end up, even if it might be said you need to be careful about using causation tests to drive the case as opposed to primarily looking at the purpose of duty. And I think where we end up probably is that you look at the purpose of the duty, and then when there's a controversial item on loss, you cross-check against that to see is that sufficiently closely related to the purpose for which the advice was given. So it's a combination of the two, really. It is what my takeaway observation is in relation to the judgment overall. But I'm sure if you asked other lawyers, they may have a slightly different take on it. Such is life, where you have majority and minority views where we don't necessarily have everyone speaking from precisely the same hymn sheet. So over to the next slide, which I think from memory, John is now going to take over and briefly canter through some past decisions.
I think, Hugh, as this is just a sort of cameo intervention, I'll leave you with control of the slide, because there's just this one. As Hugh was commenting, this is territory with which we're all familiar and practitioners have struggled for years, and indeed the courts have as well. And we're all familiar, I'm sure, with a catalogue of previous decisions, some of which have in the Supreme Court, many in the Court of Appeal, where different strands of reasoning can be discerned, and trying to extract some coherent principle from the diverse and diffuse collection of judgments that there are in this area is not always straightforward. And I have to say, with genuine awe and admiration, reading through the judgments in the Manchester Building Society case, I was struck with the position that their lordships had achieved an absolutely masterful sleight of hand in which they've managed to avoid criticising any previous decision, but really left us in the position in which we've either misunderstood them or that they are capable of being properly understood in accordance with the principles articulated and enunciated now in the MBS case. So, for example, the Caparo case, one I'm sure we're all very familiar with, is explained on the basis we're told that the purpose of the advice solicited from the auditors was to produce accurate audited accounts and not to advise, for example, potential investors into the company. Samco is explained now on the basis that the purpose of asking the valuer to advise is simply limited to informing the lender about the extent of security. Hughes Holland, which we'll look at in more detail in a moment, is explained on the basis that the purpose of the solicitor's retainer was to draw up a mortgage and not advise the lender on whether to lend. And Anico reinsurance is to be seen now, properly understood, as a case based on the question of the purpose of the broker's advice being to know whether or not there was a market for the book of business to be written as a whole. So one can see all of these earlier decisions being interpreted through the lens of what one would like temptingly to say is a new approach, but their lordships have said really was the correct approach all along. So I pass back to Hugh now to explore how this is going to impact potentially on the first area of professional negligence claims, namely auditors and accountants.
Thank you very much, John. Well, yeah, focusing on other professional disciplines then, and a quick canter through these. Many of you will be familiar with the case of Galoo and Bright, Gray and Murray. It was a case which saw a claim by the company against its auditors for damages put as trading losses and liabilities incurred. That claim was struck out in circumstances where the audited accountants negligently overstated the value of stock and WIP. However, no causal link was alleged or found between the accounting errors and the losses. Merely that if the accounts had correctly shown the company to be insolvent, it would have ceased to trade and not incur the trading losses and liabilities it did. Applying a purpose test, we asked the question, would the case be differently decided today? You may recall that this case is quite well known for its observations about a common sense approach to causation. And that was very much how it was viewed at the time. Of course, it's now rationalised as scope of duty case, and the modern approach is don't look to common sense, because one judge's common sense is another judge's nonsense. So we're encouraged to steer clear of simply asking ourselves what is a common sense approach to causation and looking at scope of duty and purpose. On the bare facts alleged in Galoo, it would probably be decided the same way post MBS, but there may be some indications that if the claim had been restructured, there may have been a possibility of establishing liability. In particular, Lord Leggett, if you look at paragraphs 118 and 119, looked at Galoo and also at the Bearings case. On Galoo, he concluded that it was necessary to plead and prove the link between the losses and those matters which the auditors negligently failed to detect and which made the accounts inaccurate. And no attempt was made to disprove the possibility that losses would have occurred, even if the value of stock and WIP shown in the accounts had been accurate. Now, just pausing there, what's interesting about that, of course, is that is influenced by Lord Leggett's view that the proper test to apply has a causation flavour to it. Query how far one can necessarily say that that is reflective of the majority view in terms of its analysis. But in any event, maybe a cross-check, but one questions necessarily whether or not it's simply a question of pleading and proving that link. But practitioners should be aware of the fact that where they're into an area such as this one, no doubt it will be advisable to positively assert your case in that way. So the possible implication was that if that case had been properly advanced, then liability for losses may have been established. The second case that was looked at, Bearings and Coopers and Lybrand, was of course a case where damages were recovered for negligently failing to detect unauthorised trading by a general manager, which thus continued. In that case, there was a link between the negligent omission to alert the bank to a risk that proper performance of the duty would have detected. So that seems to have been the other side of the coin. So far as the AssetCo and Grant Thornton case is concerned, this is a recent decision of the Court of Appeal where damages were recovered for the negligent failure to detect falsified accounts, which showed 2 major contracts as being profitable when they were loss-making. This had the benefit of analysis by Lord Leggett at paragraph 120 and 121 of his judgment. And he said there, where an auditor negligently fails to detect and report a cause or potential cause of loss to the audited entity, with the result that losses from that cause occur or continue to occur, there is ex hypothesi a causal link between the subject matter of the auditor's negligence and those losses. Thus, on the facts of AssetCo, it seems clear that the 2 contracts which the auditors negligently failed to identify as heavily loss-making were inherently likely to continue to generate further losses, as in fact happened, unless or until they were terminated. The losses on the contracts were in those circumstances losses which the auditors owed a duty of care to protect the claimant against. One might thought the lesson there is express clearly the purpose in your case as to the why the audit was being carried out. What was its purpose? I.e. the need to know if we need to make redundancies or can afford to retain current staffing levels. So losses were held to be within the scope of duty because the negligent deprived the company of information that would have caused it to cease loss-making activities. But that in itself is not enough. It also must be the case that the losses arose from a matter which made the opinion on the accounts incorrect. So Lord Leggett is very much linking purpose with a causal test when asking the question of sufficient nexus. And it's his judgment which contains an analysis of these cases. One might need to be a little bit careful about how one repackages that when applying the majority view, but those points are nevertheless useful in order to look at some of the auditors and accountants negligence cases. So I think now, John, you're going to look at financial advisors.
Yeah, thanks, Hugh. And again, beginning with some observations of Lord Leggett, which I think do chime with the majority view in the sense that he emphasised the need to focus on the risk which the advisor was being asked to address. And as you'll see from the cited with a quotation there, that what determines whether the advisor has a duty to protect the client against a full range of risks associated with a potential transaction or against some of those risks is whether or not the contribution to the decision-making process is limited. If it's not, either because the advisor is responsible for recommending a course of action or because the matters which the advisor is expected to take into account are open-ended and not limited, then the advisor's responsibility extends to all the foreseeable risks of entering into the relevant transaction. Now, how does that play out in relation to financial advisors? Lord Leggett said in a couple of places in his judgment that the position may be different where, for example, the claimant is a private individual relying on a financial advisor to recommend an investment. I was wondering quite why and what was meant by that, and was taken to the case of O'Hare and Coutts, where the court, where Coutts Bank persuaded the claimants to take on a higher risk investment than was consistent with what was eventually described in the judgment as their unconditioned risk appetite. And Mr. Justice Kerr said, as I read the authorities and the COBS, Conduct of Business Sourcebook regulatory scheme, there's nothing intrinsically wrong with a private banker using persuasive techniques to induce a client to take risks the client would not take but for the banker's powers of persuasion, provided the client can afford to take the risks and shows himself willing to take them, and provided the risks are not, avoiding the temptation to use hindsight, so high as to be foolhardy. It's always struck me as a very bank-friendly analysis that bankers are permitted to use their powers of persuasion to cause investors to shed their instincts for self-protection and self-preservation. Now, how will that case play out if one applies a purpose test to it? In particular, the investor says, I, the investor, am looking for and asking about low risk investments. And that's the purpose for which I'm coming to seeking advice from you as the advisor. Now, in the light of O'Hare, really, there are problems posed by that case. I think trying to reason it along with the MBS case, because in O'Hare, the court effectively divorced the common law duties from the bank's statutory duties under COBS. Under COBS, and I'm talking here about COBS 9 rule, is to take reasonable steps. The advisor must take reasonable steps to ensure that a personal recommendation or decision to trade is suitable for its client. Now, pausing there, if the client wants low risk investments, then being advised to take an investment which is high risk might be thought to produce ipso facto a result in which the product sold is unsuitable. The difficulty is that, or claimants face in that context, is that Mr. Justice Kerr went on to say that suitable in this context included knowledge of risk imparted by the advisor. In the context of investment advice, there must be a proper dialogue and communication between the advisor and the client. So what Mr. Justice Kerr was doing effectively was to use the COBS rules to dictate a result in what would have been viewed by the claimants according to their unconditioned risk appetite as unsuitable. It suddenly becomes a suitable recommendation to make. And if the O'Hare approach to the scope of duty is correct, then it seems to me adopting a purpose test is not likely to result in a different outcome, as O'Hare provides a route to bypassing the purpose test. I recalled in this context the decision in Rubinstein and HSBC, which raised similar issues to those that are addressed by the MBS case. There, you'll remember, the Rubinsteins had been wrongly advised to invest in a fund which exposed them to a risk of market loss, but where the events resulting in the realization of the risk were not themselves foreseeable. The background to that was that they had been persuaded by a private banker to invest in an AIG enhanced variable rate fund, which was presented as having the same risk as building society deposits, when in reality it was an investment in a range of underlying alternative market investments, which were prone to some volatility. In the circumstances which happened, the actual risk which materialised was the collapse of Lehman's and the impact that had on the AIG fund, which it was common ground could not be foreseen and had not been expected. But at first instance, the judge concluded that the unforeseeable Lehman's collapse risk was the cause of the loss, and that the Rubinsteins were not entitled to damages. That was a decision reversed by the Court of Appeal, and in particular Lord Justice Ricks, saying that it was the bank's duty to protect Mr. Rubinstein from exposure to market forces when he made clear he wanted an investment which was without any risk. And the court then said, well, it's wrong in such a case or context to say that when the risk from exposure to market forces arises, the bank is free of responsibility because the incidence of market loss was unexpected. So one suspects the case will be decided the same way today, and it struck me it was an early example of applying the purpose of advice approach or strand of reasoning. I hand back now to Hugh to talk about valuers.
Good, thanks, John. Well, it's going to be a whistle-stop tour in relation to this particular section, but for those who want to stay online to have a further chat discussion, we can do that. And of course, in due course, I'm sure we will all be looking at these particular areas and cases in further detail. So valuers, conventionally damages for negligence in surveyors' negligence cases are assessed by reference to the diminution in value of the property. In other words, a comparison between the value of the property as described in the surveyor's report and as it ought to have been described. The measure of loss is not therefore ordinarily equated with the cost of remedying unreported defects unless these equate to the difference in value. But there are exceptions to that, and if we look at a recent decision of as it happens, a Deputy High Court judge in relation to a property in the West Country, the Herts purchased a cliff top property in Devon, which was by all accounts, a property with a spectacular view, but very exposed to the elements. And it ultimately suffered from extensive damp ingress problems, and the home buyer report, which they obtained, pointed out that the property had been newly reconstructed and extended, and as a result, it wasn't possible to assess if adequate damp proofing measures had been installed. However, and critically, whilst he was aware that there may be a professional consultancy certificate, which would have given further information as regards how the construction was carried out, the surveyor, Mr. Large, did not recommend that that certificate was obtained, which would have revealed that the works had not been properly carried out. And that's really the key turning point of the case, is that this isn't a typical surveyor's negligence case when one is focusing on the report, but in fact, the failure to properly advise the client to obtain a further document, which would have then revealed further works had not been carried out. And in those circumstances, the trial judge awarded damages assessed as the difference in value between the property with the defects as reported in the report and its defects with all the defects which in fact existed, even defects which the report could not have been expected to identify. The reason for that, applying a purpose test to the scope of duty, the purpose of the duty involved advising on the obtaining of a certificate in the terms described, and that was precisely in order to obtain some protection against the presence of defects which a competent surveyor could not identify in a newly rebuilt house, and from which it followed that there were no losses attributable to risks other than the risks against which Mr. Large had a duty to safeguard the hearts. So that is a case where, notwithstanding it predates an MBS in the Supreme Court and doesn't refer to it, it is entirely consistent with it. Valuer cases, just a brief footnote mention here for those who are interested in looking under the skin of some of the quantum of these cases. Query whether or not there may be an argument for saying that actually the Samco cap, which is applied in the context of negligent valuation of properties, may be said to be wrong and overly generous in circumstances where there's a market fall. You will recall, of course, that the conventional approach is you take the negligent valuation of the property. We assume, for the sake of argument, 10 million. Its true value, if properly reported, is 8 million. Therefore, the cap, which is said to apply to the recoverable items, is 2 million. That's the extent of the overvaluation. But if there's a market value collapse and the property may lose its value down to 5 million, and the true value might go down to 4 million. So therefore, query whether or not actually the recoverable amount should be 1 million rather than 2 million. That's posed as a question by Lord Leggett, but not answered in his judgment. He does point out that there's justification for the way that particular approach is applied in valuation cases, as per Lord Sumption and Hughes Holland, as a legal rule applied in a robust way. So it may well be that, notwithstanding the observations of Lord Leggett, that survives as an approach. But the wider lesson is, don't simply use counterfactual as a mechanical exercise. Focus back on the purpose of the advice and what that gives rise to in terms of clues as to the allocation of risk as between client and advisor. We're going to skip through the last few slides, but I think briefly, John, if you can just deal with Hughes Holland and BPE. You probably don't need to deal with the facts in any great detail, I suspect, but back over to you.
Thank you, Hugh. Yes, I'll I think take this in this way, if I can, with just a very brief look at the facts and perhaps less so at the judgment, because there's some interesting points I think to be made about this decision. It'll be recalled that Mr. Gabriel had some £200,000 he was prepared to lend to a Mr. Little to develop a disused heating tower on the Kemble airfield, and he made his own commercial evaluation of that proposition by concluding that the property in its undeveloped state was worth 150,000. He thought, with the benefit of a £200,000 investment, it'll go up to £400,000. Mr. Little had other ideas, which was to use the £200,000 fund to pay off a loan. Solicitors were instructed to prepare a charge. They were aware of Mr. Little's plans and aware that the money wasn't going to be used as Mr. Gabriel expected, and prepared charge documentation which falsely, by which I simply mean inaccurately, conveyed the impression that Mr. Gabriel's money was going to be used in the way in which he expected. The result was, although full recovery of the £200,000 loss, which eventuated when the venture failed, was awarded at first instance. That was overturned on appeal and ultimately also not sustained by the Supreme Court. And the principal reason in the Supreme Court was that if the charge documentation had been drawn up in the way in which Mr. Gabriel had expected, i.e. to commit to a development of the property, that Mr. Gabriel was unable to prove that the venture would not have been entirely loss-making in any event. The point I wanted to highlight about this is that it seems to me a difficult decision to reconcile with the MBS case, although their lordships don't analyse this at all. They extract strands from Hughes Holland to support the majority approach in MBS. But the key point about the majority decision in MBS is the rejection of a counterfactual test. And it was in fact very much the counterfactual test which seems to have driven the ultimate decision in Hughes Holland. If one sits back and asks, well, if the solicitors had pointed out to Mr. Gabriel, your money isn't going to be, under the present arrangement, used to fund the development at all, but is rather going to be used to repay a loan, only three things, it seems to me, could have happened. One is that Mr. Gabriel would have simply walked away from it there and then, in which case obviously he wouldn't have suffered any loss. Alternatively, which is more likely, he would have had some engagement with Mr. Little. That could have only resulted in two outcomes. Either Mr. Little would have said, well, I need the money to repay a loan, in which case Mr. Gabriel would have walked away and again not suffered any loss. Alternatively, the third possibility is Mr. Little would have yielded to Mr. Gabriel's demands, and the money would have been allocated, if it was possible, to development of the property. And it seems to me it's only in that third scenario that it would be correct to find that Mr. Gabriel's losses were not coverable. Fact is, in the case, no one seems to have gone into that aspect of it at all. And what we end up with is a decision driven by a hypothetical counterfactual scenario, which simply did not reflect the reality of the case. So for those reasons, I struggle somewhat with the interplay between those two decisions, but no doubt I would be told you've not properly understood them. I pass back to Hugh then to wind up.
I don't think I've ever said that about any case you've analysed, John, so I wouldn't possibly say it in front of an audience today. Shall we move on then briefly on solicitors? Just if you want a reference for a case where a counterfactual case doesn't really work, look at paragraph 105 of Lord Leggett's speech, where he analyses one particular instance of where using the counterfactual type analysis as per the old-fashioned sort of Sanko type approach doesn't really elucidate. I won't go into that in any detail now, but in case you're interested in looking at it, there's a discussion there, and there's also a paper you can look at which looks at some cases where the counterfactual case doesn't really work. So I think that probably concludes the talk today. There's lots still to chew over and argue about arising out of the decision in NBS and how it impacts on cases. But I think broadly speaking, most practitioners welcome it as laying to bed the need to angst over whether or not we categorise a case as an advice case or an information case. I think Hughes Holland started the move away from that, and MBS has confirmed that move away so far as a test to apply is not the test to apply, and one is probably into an area now where one needs to look much more closely at the facts of each individual case and drill into the purpose for which the professional advice was given when asking oneself tricky questions as to how much of the loss which has been suffered on a but-for causation test is in fact recoverable. So thank you all for joining us and with staying with us, notwithstanding the slight overrun. We hope you have a good day or good rest of the day. So far as the question of questions arise, I think the chat function has popped up one or two questions, I think. So let me just see if I can look at whether or not we've got a question. We indeed had from none other than His Honour Judge Russen QC, who asked the question, on the mixed quantum point in Kahn and Meadows, I have not looked at the first instance judgment, but wonder whether what the Supreme Court says in paragraphs 11, 49 and 68 means that C would recover the exacerbated by autism costs of haemophilia. And that may well be right. It may well be that there is an intermediate point there which needs to be looked at. Should we go back and briefly look at Kahn and Meadows? John, you're closer to the facts than me, so I don't know if you want to respond to that point or not. I think
probably time doesn't permit, in the sense I'd want to go back and have a closer look at those three paragraphs. But I have every confidence that Judge Russen will be right about it.
I'm here, John. I wouldn't share that confidence because I was only looking at it very swiftly, and indeed so swiftly I don't know whether they remitted the case to Mrs. Justice Yip on quantum. But it just seemed to me that on Hugh's point that the costs were greater in treating the haemophilia due to the autism than would have been the case in the case of standalone haemophilia. It wasn't clear to me from the way they expressed themselves whether or not they were eliminating Hugh's additional costs, but equally, I'm not saying they included them.
No, I think you're right. I mean, paragraph 11 doesn't really actually answer the point, does it? It appears to contain an admission that there's a ability for compensation for the additional costs associated with the haemophilia, but denied responsibility in relation to the additional costs associated with autism. Whereas I think my point was really more to do with the fact that the costs associated with autism without haemophilia should probably be treated as unrelated, but the additional costs of autism associated with a haemophiliac might arguably be.
Yes. That's what's not clear to me from the later paragraphs. But
no. So anyway, it's maybe something to keep an eye on for future cases, and it may well be said to be arguable that the reasoning doesn't preclude that. And I suppose it depends on where we land in terms of how judges approach the sufficient nexus factor 5, doesn't it, in relation to the helpful list of factors as to where we end up with that and on the facts of any particular case.
But thank you from me for a very interesting and educational talk.
Good. Well, thanks very much for your question, and it'd be interesting to see if there are any other questions anyone wants to raise. But obviously, everyone's got busy days ahead of them, no doubt, and it may well be that they don't. But we'll stay on for a few more minutes just in case anyone does have any further questions. I mean, I suppose the only other thing I would mention, John, while we're waiting for any further questions, is that in relation to these sorts of things, one needs to guard a little bit off the back of recent Supreme Court cases from thinking that they are giving us advice on all the questions we have or problems we have in recent cases. And of course, there are all sorts of other tools available in the toolkit of judges and practitioners to analyse cases. We mustn't forget, but for causation is obviously a key part of the threshold which you already have to cross, and we mustn't also forget that there's a remoteness test to apply at the end of all of this, and other tools such as novus actus, contributory negligence, etc. So it I think is it's important to keep in mind the role it plays within professional advisor negligence cases is quite large, because often the amount of loss is the key issue. But conceptually, it probably is important that we don't allow it to engulf us, if I can put it that way, when analysing professional advisor liability cases.
Yes, I note there's a comment that in the chat function that my recollection is the Supreme Court expressly said they were not overruling or interfering with Hughes Holland, and that is certainly the case. It's addressed expressly. I think my issue with it is, as I've outlined, that that there are strands in it that are extracted to support the majority view in MBS, but I think there are real conceptual difficulties of reconciling the two cases, which with which there was no process of engagement.
I wonder, John, whether or not that might be conceptually analysed back by reference to the question that Mrs. Justice Yip posed to herself at first instance in Meadows and Khan, which is whether or not you answer that question by reference to whether or not the you make a distinction between the mother who would have terminated for haemophiliac or for any reason, if you see what I mean. And it may well be that you can rationalise the decision in Hughes Holland on the same basis, that you do need to have the link between the breach of duty purpose element and the loss in fact suffered, if you see what I mean.
Yeah. Now, I suppose if the purpose of the advice in Hughes Holland that was solicited was, I want protection for a development loan, and what you end up with is not a development loan, it's something else, it's difficult in my mind to see why recovery shouldn't follow. But yeah, I mean, as ever with these things, it's the answer is often determined by how the question is framed. So there's plenty still to argue about in that respect. Good. Yeah. Well, I think probably we've run our course in terms of the chat function, and thank you, John, for speaking with me on the topic today. And unless there's anything else you wanted to say, I hope everyone has a good day, and we look forward to seeing you again on one of our future webinars, or indeed in person in due course. Good morning. Thank you. Goodbye.